Are you a software engineer concerned about giving away your tech? If you're in software, you need to understand a little intellectual property law at a high level to protect your work and prevent a royalty free tech transfer. In this video, I'll give you a high level overview of intellectual property law, and at the end of the video, we'll apply what we learned to see how Cursor could protect their IP. My name's Dennis. I'm an intellectual property attorney, electrical engineer, and software developer, and I see software developers confusing and messing up IP law all the time, especially the different regimes. Correctly categorizing your IP matters because the different IP regimes have different requirements and varying protections. Knowing a little in this area will go a long way. So here's the advice I would give my clients, but unlike them, you won't be paying hundreds an hour. In this quick video, I'm going to give you a 100,000-foot view of IP law and help you identify the three main categories: patents, trademarks, and copyright. Let's start with patents. Patents grant an exclusive right to the inventor to prevent others from making, using, or selling an invention. Of interest to software developers is the utility patent. Utility patents cover machines, manufactured articles, and processes. Software falls under a process. But as you may have heard, software patents are hard to come by and they don't protect a lot. That's because not only do they need to show that the invention is novel and not obvious, but software also butts up against several exclusions to patentability. Specifically, the law prohibits patenting abstracted ideas, laws of nature, or natural phenomenon. Courts often consider software abstract because the patents claim algorithms or mathematical formulas. So to make it not abstract and patentable, the patent must claim a specific computer improvement. For instance, improving performance for a relational database. That sounds like an obvious step, but inventors don't like tying it to a function because as soon as you've said what an invention is, you've said what it isn't. So if you claim your invention improves speed for a relational database, it's probably fair game to use it for a spreadsheet application. Patents are the broadest and the most comprehensive way to protect software, but they are also the most difficult to obtain. In the US, you have to file your patent application within 1 year of public disclosure, and in other parts of the world, it has to be filed before public disclosure. You definitely should hire an attorney. It can take years to get through the patent office, and it'll likely cost you $15,000 to $20,000. That difficulty in obtaining a patent stands in stark contrast to copyright. Unlike a 2-year process with tens of thousands of dollars, you get a copyright in your work the second your code saves to the computer. But copyright protects human expression of ideas, facts, and processes, not the underlying idea or process. A famous law school example illustrates this well. This is a bike rack. So how much of that design is functional and how much of it is artistic expression? Is it a creative expression of human ingenuity, or is it simply a functional shape to lock your bike? The courts ruled in this specific case that the bike rack's aesthetic elements were inseparable from its utilitarian purpose and therefore not eligible for copyright protection. So software has the same problem. To what degree is, say, an API's function separable from its expression? Obviously, this tends to be a matter of taste and opinion that's hard to predict. A for loop is not copyrightable. But what about a for loop in context of an LLM streaming response? Maybe. Copyright allows the holder to prevent others from reproducing, distributing, or creating derivative works. But as you can see, software won't have a ton of protection beyond outright copying and pasting. And that makes a lot of sense if you look at other creative areas. For instance, you cannot make the movie Terminator 4, but could you make a movie about a robot sent back through time to save humanity? Probably. Likewise, you could make an ORM, but you can't steal the source code of an existing ORM to do it. Though you could be inspired by another library, just like you could be inspired by the Terminator to make a similar movie. Last point about copyright. A lot of people think you need a copyright registration for it to be enforceable. That's not true at all. As soon as you write it down, it is copyrighted. There's an additional step called a copyright registration. I've made other videos about it. You can go take a look at those if you want it really in depth. But the high level is you only need the copyright registration if you're going to sue on it or if you want statutory damages. That's it. Otherwise, copyright registration is not needed. So that's going to bring us to the third main IP regime, trademark. Trademark isn't directly applicable to pure software developing, but it will rear its head in any kind of business or side projects. A trademark protects symbols, names, products, and slogans used to identify goods or services. You get a trademark as soon as you put the mark into commerce. Most people are extremely confused about this, and they think a trademark needs to be federally registered, but that is not the case. As soon as you put a mark into commerce, you get a common law trademark. A national registration is going to give you several advantages, with the biggest being nationwide coverage. For instance, if I open a software consulting business for JavaScript in Arizona called Types Aren't My Script, I would be able to exclude others in my market. But that relevant market is open to interpretation and argument. However, if I have a nationally registered trademark, then no one nationally can use it, period. You couldn't open the same business in Florida, say, you would be excluded by the national mark. A quick aside on trademark. There was recently an open letter asking Oracle to disclaim their JavaScript trademark. While that can be done for their national registration, I've been unable to find any case law on how or even if a trademark can be disclaimed at common law. A letter stating it's disclaimed is probably enough, but I don't think it's ever been tested. So now that we know all of this law in the abstract, let's make it concrete and look at how Cursor could protect their IP. Cursor is the new AI-focused IDE that's a fork of VS Code. Now, I don't want to get into the moral discussion about if they should protect their IP, given that they're riding on the backs of Microsoft's VS Code, open source goodwill, and all. This is just an academic hypothetical for a technology that most of you will know. So the most valuable IP is the commercially relevant IP. There's plenty of IP that makes no money, and rarely are you going to want to protect that. So the first step is to identify what your commercial secret sauce actually is. For Cursor, I would argue it's the integration of your codebase with the models. Specifically, how and where they tokenize the codebase, chunk, and prompt the models in a way that gives actionable rules to diff code, create new files, and auto-tab a file. A company with an unlimited IP legal budget will start filing patents on any novel software. But if you're a startup and money's constrained, it's good to think a little bit more. Specifically, a lot of Cursor's special sauce concerns getting the best output for a minimized input. But in the next 2 years, the time it takes to get a patent, how much will change in token limits? Will a lot of what makes Cursor special today matter in 2 years? Probably not. So I advise them to keep as much of their IP as possible on their servers in secret. Keep the API calls between the editor and the server vanilla, and favor API over local where the code can be examined. So keeping it secret is utilizing another IP regime, trade secret. With a patent, you must disclose your invention so it can be copied when the patent expires. But with a trade secret, your employees, your vendors, and you promise not to disclose your IP. But you can probably see the problem. When Apple goes to OpenAI and demands a non-disclosure agreement, it'll happen. But when Cursor goes to Claude for agreements, Claude probably doesn't even pick up the phone. Therefore, whatever prompts Cursor sends to OpenAI or Claude, that IP is disclosed, and worse, those companies can use it to improve their own offerings. So, am I saying that Cursor has little way to protect their IP? Well, if we're assuming that their IP of today will be rendered moot in the next 12 to 24 months, then yeah, that's exactly what I'm saying. I've regularly advised my tech startups that were in similar spots that they're going to have to win this as a business, not as a collection of patents. So I was saddened actually when I signed up for Cursor and saw a modest discount for a prepaid year. I decided to pay monthly because, frankly, I fully expect that within the next year, VS Code, JetBrains, Zed, or somebody else will make a compelling competitor. They should have offered a substantial discount of 1 to 2 years prepaid so customers stay somewhat interested over that horizon as other competitors rise. But for companies with IP that should ride out more than 2 years, patents make a ton of sense. I think of the local first databases like Terso, Electric SQL, or even Prisma's upcoming offerings. I'm sure that there's a lot of methods in that tech space that will be relevant for many years. So I hope that that quick walkthrough was helpful. Let me know in the comments if you have any other questions and I'll answer them in upcoming videos. And then please be sure to follow me for more legal tech commentary and content.